Good evening to everybody.
Good evening, Chair.
How are you, Ms. Botha?
I'm very well and happy to proceed with this bill. Thanks a million.
Yeah, no, we need to finalize it now. We need to finalize it as soon as we can. We are left with 2 minutes before we start. Thank you very much and good evening. Good evening to everyone on the virtual platform, and a special welcome to our interdepartmental officials from both Justice and SAPS. I'm not sure whether social development is a part of the meeting. Is social development part of the meeting? It does not seem so, but welcome to everybody who is part of the meeting. We will be dealing with the register for sexual offences. We'll be getting a briefing as per the decision of the meeting before we adjourned. We asked the three departments to go and work together and present something to us so that we can be able to finalize these three bills. We need to finalize the bills by the 4th of June. They need to be before the House by the 4th of June. They have been outstanding for some time. So by next week, we should have concluded the bills and observe the 3-day rule so that by the 4th of June, they are debated in the House. And thank you very much for all your hard work and dedication for both members and for the supporting staff that have been supporting us. Who is going to lead us on the presentation?
Is that so? Good evening, Chair.
Good evening, teacher.
Yes, I'm in a boardroom with the DDG for Court Services, under whose branch the NRSO currently lies. That's Advocate J.B. Skosana, and we are supported by Advocate Prince Mkambule, who is the head of PRVG. That's people, vulnerable groups, including sexual offences matters, and the register herself, Ntombi Machila, here. So with your permission, I'll ask Advocate Nkambule to make a presentation as requested by the Portfolio Committee. Thank you, Chair.
Thank you very much. Before she does that, can I also welcome the delegation from the SAPS? Who is leading the delegation from the SAPS?
Thank you and good evening, Chair. Good evening, DG, and all the other honorable members. I'm General Sintumule, and I am the head for Forensic and Detective Services. I'm leading the delegation. The National Commissioner is with the Minister for a press briefing after our budget presentation today. But I have with me online General Lisija Mangale, who is an expert on CRC, and other colleagues. Thank you, Chair.
Thank you, General. It will be good if we can see your face.
Excuse me, Chair, I think I missed that part.
I think I was saying that it can be good if we can see your face.
Not a problem, Chair.
Thank you very much.
Thank you very much, Chair.
Thank you, General. Thank you. So, yes, who is DG Justice? Can you take us through?
Thank you very much, Chair. I ask my colleague, Advocate Prince Kambule here to take us through the presentation. They are uploading the presentation. I'm not sure if, Chair, you are able to see the presentation.
Yes, I am, DG.
The presentation is on the screen. Advocate Kambule, you can proceed. So, if my laptop was not here. No, don't. Here you speak. You can move there, but here you speak. You are speaking here, but then you.
Oh, okay, thank
you.
you.
You can sit there and help us moving the slides.
Our apologies, Chair, is technical glitches that we're experiencing.
How much time is doing it?
All right, Chair, with this presentation, we would like also to know as to how much time will be given for the presentation.
40 minutes.
Thank you. First is to say that it is a presentation that is responding to the request that we received from the committee that we should be meeting as the department, so that is the Department of Justice and the Department of Social Development as SAPS, so as to, and also the Department of Home Affairs, so as to consider the question that we received from Parliament. First, then the presentation, of course, is going to be looking in all those, and also to look into the resolution that was taken by the task team. So we were requested that we convene, that is DOJ, SAPS, and Department of Home Affairs, and also the Department of Social Development, to explore what would best serve as South Africa, given the challenges faced with the current constrained fiscal environment. That is the question that we were asked, actually the task that we were asked to look into. So DOJ then established a task team, an interdepartmental advisory task team consisting of SAPS, the DSD, and the Department of Home Affairs. And we met on the 29th of April, 2021, but the Department of Home Affairs could not make it. So the reason for us to meet first is also to indicate that it is what Parliament is looking into right now, with the bill that is actually expanding the NRSO scope to include particulars of all sex offenders beyond the offenders against the children, that is beyond offenders convicted of crimes against sexual offenses against children and persons with mental disabilities, and also to include other vulnerable persons, that is female persons between the ages of 18 and 25, persons with physical, intellectual, and mental disabilities, and also persons 60 years of age and older. And also to increase then the period for which the sex offenders must remain on the NRSO before they can be removed from the register. So these are the amendments that the committee is sitting with. And of course, there are also the amendments that the committee is also responding then to the 24 demands that were coming from the total shutdown in 2018. So the committee, the task team, the task team set and made these considerations. First, to look into the major purpose for keeping the register. And secondly, what will be the need for us to consider what other countries are managing, how do they manage the register, and also to look into the inherent interdependencies between the stakeholders, and also to look into the need for an effective interface of electronic data systems between the stakeholders, because there is an exchange of data between all these stakeholders. So what it means is that there must be a point where the stakeholders then are able to do the data sharing. And then also the need for the collection of the disaggregated data for both accused persons and the crime victims, as required by the Presidential Summit Declaration against gender-based violence and femicide. Because as a country, we are a country that focuses in terms of crimes, we focus mainly on the particulars of the accused, and we pay less attention on the particulars of the victims. So this is a gap then that the Presidential Summit Declaration is looking into addressing. And then the next thing that then the task team considered as a matter that needs to be considered in order to respond to the task, that we also need to look into the issue of resource sharing between the stakeholders, so that we are able then to collectively establish a repository that will best serve the GBVF survivors and also address the issues and the constraints that the country is experiencing in terms of the fiscus. And then the other is, we also considered then the resourcing and costing as one of the critical issues that need to be considered, as well as then the need for the enabling legislation for the repository. It doesn't matter which one, but then there's a need for it, because that is the global trend, that every register be backed up by a piece of legislation. So we made then the examples of those that it's not the only register that we have in the country. We have also the National Child Protection Register, which is also backed up by a piece of legislation, the Children's Act. And we also have the Register for the Abuse of Older Persons, which is also then catered for by the Older Persons Act. And also then the CRC is also is also backed up by a piece of legislation, and we also have then the NRSO that we're dealing with right now. So the committee also considered then the global purpose for keeping the register. That first, this is one thing that is common to all countries that are keeping the register, that it is kept to prevent the new sex offending and also the re-offending, both so by the international sex offenders. And secondly, it is to prevent pedophilia. And then thirdly, it is intended then to monitor and track sex offenders following their release into community, and also to support the research initiative to guide the effective prevention, response, and support programming of the country, so that we are able then to channel the resources where they are mostly needed. And also it is to provide offender and victim profiling analysis, which is quite important, because as a country, you cannot fight what you do not know. So we need to know as to which ages are actually responsible for sex offending, and also the other particulars in terms of the demographics then of the sex offenders. And also to prevent sex offenders of foreign jurisdictions from entering our country. And as we know that it is also part, our legislation, that is chapter 6 of this act, also has a provision that then prevents, seeks to prevent foreign sex offenders from entering our country. And then also to contribute in the elimination of GBVF in the country. As we know that sex offending has a relationship with domestic violence, and also has a relationship with trafficking in persons. So all those then, we cannot say as a country that we are looking into sex offending only, because they all belong to the same family of GBVF. And most importantly, is to help then the government to capture the magnitude of sex offending in the country, so as to know as to what resources that need then to be allocated. And then the next thing that then the task team then we said that needs to be considered are how are other countries then managing the entries, the removals, and also the public accessibility of the register. So in South Africa, Kenya, US, and Canada, it is the state that is responsible for the entries into the register. It is only UK where then you find that the register is located with the police, and there is a piece of legislation that then controls that. And when it comes to the removals of the details of the sex offenders, generally persons are placed in the sex offender registers, and they remain in, that is globally, for a period ranging from 2 years to an indefinite term of registration, depending, of course, on the sentence imposed on conviction. In South Africa, then we are different, because our period, the minimum period in South Africa for a person to remain in the register is 5 years to an indefinite term, and that indefinite term applies to convictions, that is repeated convictions, and also to a sentence of 18 months and above, that is imprisonment sentence of 18 months above. If a person has been convicted of 18 months, imprisonment sentence of 18 months and above, in South Africa, you remain in the register indefinitely. So the issue then of accessibility, there are commonalities also in terms of how countries are managing this. While some countries restrict open access to the register, some have mandated that sex offender information websites be created and maintained by every state and made available to the public. So in South Africa, it is one of the issues that then Parliament is considering. So we're going to be dealing with it as I move on with the presentation. Now, the task team also noted that there is a need for an effective interface of electronic data platforms. And this is due to the interdependencies that are between the stakeholders that are responsible for the sharing of data. So then it proposed that then we need then that platform that must facilitate the support and management of interdependencies between the stakeholders, where we have a platform where it's going to be easy then for the stakeholders to share data without waiting for the written request. And then secondly, we must have an interface that is equipped with a function to promote resource sharing between the stakeholders, and also to manage the data sharing and the effective process flow between the critical stakeholders, that is a DOJ, SAPS, and also the Office of the Chief Justice, and Health, DSD, and other departments there. And this must also be done on the IJS transversal hub, and we must also be able then to collect the details of both the accused persons and the victims as required by the Presidential Summit Declaration. So if we have this interface, then it will help us then to improve the data integrity. Now, the next slide is actually depicting here the information that is shared by 6 key stakeholders. First, then, SAPS requires then the court orders, that is the convictions and the sentences from DOJ. It also then requires the data for the DNA database that they are collecting in terms of the Criminal Law Forensic Procedures Amendment Act of 2013. Then DOJ also then requires some data from SAPS, which are the fingerprints numbers and also the written confirmation for the pending investigations and charges when considering the applications for removals. And also we need some information for the historic convictions, which SAPS has been forwarding us that data. Now, coming to the judiciary, then DOJ also then requires from the judiciary the signed court orders, which are submitted in a prescribed form in terms of the regulations, that is Form 5, so that then there are entries that are done. Otherwise, an entry cannot be done until then the registrar has received that court order. Now, coming to DSD, DSD requires from DOJ convictions and sentences in terms of sentences that involve children. And this is for the purposes of the maintenance of the Child Protection Register. So they also require from us the court orders for unsuitability to work with children, which are the court orders that are made by our courts. We are forwarding that information to them in their prescribed form, which is Form 25 and also Form 28. They also require from us data, which is for the older persons register. So there are those interdependencies that are between all these stakeholders. Then coming then to DCS. From DCS, the Department of Justice requires the historic convictions, and also then the Department of Home Affairs and Department of Justice, then from Department of Home Affairs, then will be requesting them to give us the country entries of international sex offenders. It is a task that we are still dealing with, engaging with the Department of Home Affairs. Now, the next slide is showing here the IJS transversal hub, which shows then the progress that has been done by IJS to ensure that there is there is a smooth data sharing between the stakeholders. And the stakeholders that are already there, it is DOJ, it is SAPS, it is NPA, DSD, the Department of Home Affairs, and also the Department of Correctional Services. What it means is that we can, with this interface, then it will be possible then for these stakeholders to be able to share the data that is required by the NRSO. And also then the only one stakeholder that is actually in a process of being integrated is the Office of the Chief Justice. That is where then we need then the written orders so that we're able then to make the entries. Now coming to the issue of the location of the NRSO. The task team noted the key factors to be considered when determining the location. That first, that we need to look into the legislative mandates of the stakeholders. And secondly, we need to maintain the focus on the prevention of sex crimes, because that is actually the purpose, the main purpose of the register. And also then we also need to look into the systems update. It's very important that then we have a system that is in line with the technological advancements that we have that are already there in the environment of technology. And we need then to also look into the ability to collect disaggregated data of offenders as well as the crime victims. And also, we also need then to look into the budget and resources that will be needed, and also the shared resources that will then alleviate pressure from government's fiscus. Now, from the presentations that were made previously before the committee, so we did that extrapolation of the 10 salient issues that were raised from the two presentations, which we believe that they will assist the committee in making a decision in terms of the location. First, the NRSO, of course, was established in 2009, and its services are currently centralized, but we are in a process then of decentralizing the services so as to ensure that then when people are able then to apply for removals and for vetting at our courts. And now coming to the CRC already has a geo spread of 97 local criminal record centers with 36 service points nationwide. And the CRC has been in existence for many decades when one has to compare it with the NRSO. And then secondly, the NRSO is a national repository that is intended to capture, that is tasked to capture the particulars of sex offenders convicted of sex crimes involving children and persons with mental disabilities. And as we know that the bill is seeks to extend the scope of the victims, the scope of the operation of the NRSO or the protection of the NRSO to all victims of such crimes. Now coming to the CRC is a database for all crimes, and is a database for all crimes without any dedicated focus to GBVF crimes. And the third point is then the NRSO, it provides protective measures intended to discourage sex offending whilst preventing repeat sex offending. So what it means is that the NRSO has got this dedicated focus, which is to reduce then the incidence of sex offending in the country. Now coming to the CRC, it does not have the prescribed protective measures offered to GBVF victims, but then it does practically SAPS does not publish the details of the victim, and they are using that as a protective measure for victims of GBVF. And number 4, then the NRSO, it keeps details of both the sex offender and the victims as required by the Presidential Summit Declaration. And it does provide the disaggregated data of the victims to a certain extent. And the department right now is in a process then of including other variables so as to make it broader, that is in terms of the demarcation, I mean the demographics of the victims. Now coming to the CRC, it captures the records of convicted offenders only. Now, number 5, the NRSO is also intended to assist in determining the sex offending trends and profiles of sex offenders and victims as required by the Presidential Summit Declaration against GBVF. Now coming to the CRC provides offending trends. It may provide offending trends and profile of sex offenders only, since it does not capture the details of the crime victims. And I may also indicate to the committee that it is possible with the system, with the upgraded system of the NRSO, it is quite easy to get the details of the victims, that is the disaggregated data of the victims, that is the children and persons with mental disabilities. Now, when it comes then to vetting, the vetting services with the NRSO are considered as free because we do not actually ask the complainants or the applicants, to provide any fee. But of course, then when it comes to CRC, the CRC, it's got a fee of 150 for police clearance certificates, and it also provides then it requires a fee of 70 rands when it issues the police clearance reports. The NRSO is currently now coming into the capacity that is the numerical human capacity. The NRSO is under-resourced. It has a capacity of a director and 3 permanent data capturers. But then the department is in a process then of adequately capacitating this office, and in the national office and also in the regions when we are implementing, when we'll be implementing the decentralization of the functions. But I would also like to say that when we were upgrading the system, we ensured that it is a system that actually does a lot of work and with minimal demand for warm bodies. Now, when it comes to SAPS, SAPS has a capacity of, it's not 482 a chairperson. They have given me a revised figure to say that this is, it's 897. So they have 897 personnel country-wise that are responsible then for the management of the CRC. And they have also 929, 495 personnel for police who are responsible then for the issuing of the police clearance certificates. Now coming then to the budget then I would, for the NRSO, there is a slide then that is looking into this, that also deals with the plan, the implementation then of the plan in terms of accommodating then the amendments that are proposed right now. So, but currently then in year 1, the budget that will be required, excluding then the resources for the upgrading, the further upgrading of the system, is 13,320, is 13 million, is 13.3. And then when it comes then to SAPS, the SAPS then have an estimated budget of for the LCRC, that is the local CRC, is 28.6, and then for PRC is 120.4. Now coming then to the update, the systems, the position of the systems. Now coming to the NRSO has been annually upgraded since 2018, when we temporarily suspended the functioning of the register. So now it has smart functionalities, so that sort of ensure that then it is able then to provide the functions with minimal demand for warm bodies. And now when it comes then to CRC, SAPS presented previously to the committee that they will need an update of their system. And there are, of course, the interdependencies that I have already mentioned previously. And all those salient issues that will assist then the parliament to decide, the committee to decide on the location. And the ADT acknowledges the inherent interdependencies between the stakeholders, that's for one. And secondly, it be on how the stakeholders should jointly share resources for the effective management of the register. So now coming to the constitutional issues regarding the publication of the offenders details, so that is to make it accessible to the general public. So at first, as we know that the Constitution is, every piece of legislation has to bow to the supreme law of our country, which is the Constitution. So it is a criminal offense for anyone to intentionally disclose or publish information contained in the register, except as and when necessary to give effect to the provisions of the Act. That is the current status of the register. So what it means is that then a person, it is the employees, is the certain categories of people who are allowed then to get that information, but they don't have an access to the actual register. So they make applications to the National Registrar to get the details of the people, to say as to, is the person registered or not? So it's basically restricted in that fashion. And secondly, now when it comes then to the right to dignity, it is a right, of course, that is enshrined in Section 10 of the Constitution, and it is held as the heart of the individual's rights in a free and democratic society. So what it means is that then, if we are making the register public, then we will be then infringing the right to human dignity. And also, if NRSO is converted from a strictly controlled access register as it is right now, it will attract the possibility of lifelong punishment, humiliation, and harassment that may be endured by the registered sex offenders. Now, coming then to Section 9, which is which encapsulates the equality clause. So if the NRSO is published online, that will draw a differentiation in the treatment of sex offenders and also the other offenders of other violent crimes, because we do not have a piece of legislation that currently requires the offenders of other violent crimes to be published. So it might show some kind of an imbalance in terms of the protection of the constitutional rights. And now coming to Section 28, Section 28 safeguards the best interest of the children. So it will not be in the best interest of a child who is a sex offender, that is number one. And secondly, the child of a registered sex offender, to publish the details. It should sort of infringe their rights to the best. It will not be in the best interest of the child. And it will also serve then as an indirect punishment to the child. And also our constitution also makes a provision to the right to privacy. Of course, then if we make it public, then it will also be it will be infringing the right to privacy of the sex offender, unjustifiably so, and also be it will also be it will grant the public unobstructed access to the inner sectum of the person, denying sex offenders any degree of control over their personal information. And also, if we make it public, then the NRSO only limits the privacy rights of sex offenders in as far as sharing of information about sex offenders to prohibit their employment to service points with direct access to children and persons with disabilities. So meaning that in this context, employers then are obligated to keep the information obtained from the register confidential. So what it means is that as we stand right now, the NRSO, that is the Act, respects then the right to privacy of the sex offenders. And also then by allowing it, then it will also be an infringement of the right to freedom and security of persons, because it will allow public access. Allowing public access to the NRSO could also result in sex offenders and their families living in constant dread of discovery and community vigilantism, which is something that was also raised by the civil society to a certain extent. And also then access to information, and also then when it comes then to trade, occupation, and profession, in making then the NRSO public, then we might also limit the job prospects of sex offenders unreasonably, where such employment is required at areas having no direct exposure to children and persons with disabilities, meaning that then people will not be able then to provide their services, despite the fact that then they will not be having any exposure to children and persons with disabilities. Now, Chair, coming then to the considerations given to the possible chilling effect on economy and in increasing the regulatory burden. We have considered this, and these are just a few that are actually the issues that we would like the committee to consider. That if we then if we include the females under 25, then what will happen is that first is for us to say that as a department, we would like the committee to note that we could not find any empirical evidence on the impact of the inclusion of the females under 25 in the protection that is provided by the NRSO. However, as it stands, it reasons then to say that females under the age of 25, they form a large part of population, and they are also economically active to an extent that they are actually economically active. So they are there, to apply for jobs and so on. So then if this inclusion is passed, then it might have some kind of a negative impact on them. Then practically, it will also mean that the employers of young persons will have to vet all employees under the age of 25 which might be a lot of them, because as we know that in terms of our population, the youth is above 60% of the population of South Africa, which stands at 59 million right now. And this might add more resource demands, because it would mean that then there will be a lot of influx then of the applications for vetting that will be coming to the registrar. And then thirdly, that the potential of unintended, it has an unintended consequence to the employers, and making them to be slightly reluctant to employ females under the age of 25, because of the obligation that will be upon the employers to ensure that they are vetted before they join the employment sector. And also then the ambit of the proposed option, that is to include the females under the age of 25, is extremely wide, and it will in all likelihood impact on the larger workforce of South Africa, since then we have a population rate that is quite huge, that is for the youth, to an extent that nearly all employees will have to be vetted in the country. And also the inclusion of the particulars of all convicted sex offenders, however, will reduce the use of the warm bodies, as the demand to select certain categories of victims will be done away. Meaning that now with the amendment that the committee is considering now, of ensuring that that we extend the protection of the register to all victims. So what it means is that now it will quite be.
Apostle Kambole, the left is 5 minutes.
Thank you, Chair. Now coming to the IT infrastructure, now with the NRSO, as I have mentioned, that is for the smart functionalities, then and is also aligned to the most recent technological advancements. And with SAPS, then it will require the upgrade. And also then with the NRSO is linked to courts, which are the major data source. So it's quite easy then to access the information that is required. And then with SAPS, then we'll have to have it connected to the courts and IT infrastructure. And then the NRSO has been also upgraded then to detect cases that are inadvertently omitted by the courts. So there is no one who can miss registration in terms of the system that we have right now. And it also automatically sifts and enters all the relevant convictions, that is from our criminal ICMS integrated case management system. So it is also fully operational, as it is also with the CRC. The CRC is also fully operational, but then it will have to keep also the data of the foreign offenders, and also to ensure that it captures then the information that is required for sex offending. Now coming to the plan is, of course, we have done the plan, and it deals with the upgrading of the system, and that we will not be needing the budget, because it's just a small item that the department has already started to do, to incorporate the proposed new sexual offences and other necessary variables. And then we will also then, we're in a process then of updating the NRSO to include a platform for decentralization, for the decentralized functions. So there is a budget that will be required, which is 4.5. And the shifting of the personnel, I have dealt with that. And then our HR now is busy doing the work study and the job evaluation, so as to develop the structure for the NRSO. And the personnel that will be required for the NRSO is 76 personnel. As I have said, that we have a smart system that does not require a lot of warm bodies. And the budget is 11,078,000 Then we will also have them to develop the systems integration, which is something that IJS is working on to integrate DOJ with SAPS, and the budget there is 5 million. And of course, then there is an online portal that the department is solution so as to ensure that then the decentralized functions are able then to provide all the vetting and all, but everything to be done, the applicants to be able to apply online for vetting and also for the removals of name. It's something that then we're also working on. And also the SMS notification so as to ensure that the applicants are kept updated of the progress of their applications. And also then the training and so on. So I have already indicated then the budget. So this slide, I think what is important on this slide is to look into the conviction trend in sex crimes, that the caseload for 2018-2019 of offenders who were convicted of sexual offenses, 3,291. And in 2019-2020, 2,075. So what it means is that this is actually the caseload that we're looking into in terms of all the convictions then that will be, if we then extend the scope of the application of the register, that's the caseload that we're looking at. And then these are actually the options that were actually discussed with the portfolio committee. So I think that it's something that is already before the committee. Now, what we are saying as the task team is that in considering this issue, these are the salient issues that the committee will need to consider above all that we have presented, that there will be a need to build the technical knowledge in the receiving department. It doesn't matter where the register is. There will be a need for the development of that technical, that interface, because of the serious interdependencies. And all these interdependencies are inherent. So there is no way that we can avoid them. So it doesn't matter where it is established, but there will be that need for that interface. And then secondly, as we have presented previously, SAPS presented and said that they will need additional human resources and other resources. And the same applies with the Department of Justice. So including the skills transfer and so on, that will be needed as well. And also the new hosting home will have to develop its own processes and procedures, which is something that the Department of Justice spent years and years developing and cleaning up and revising and so on, until it got to a point of having it up and running. And second, and fourthly, the upgrading of the system, there will be a need for the upgrading of the system to fully incorporate the NRSO. That will be needed. And we also want to say that government has spent millions of rands to upgrade the NRSO. And yesterday I was in conversation with IJS and also ICM and our IT people. So they said to me that they've spent over 30 million upgrading the NRSO that is starting from 2018. And the other point that would like the committee to consider is that the NRSO is built to automatically sift and enter all convictions. So what it means is that we don't look for this data. The system is already capacitated to identify the actual cases so as to stop the contamination in the data system. And also then the inclusion of the NRSO in the GBVF NSP, that is the National Strategic Plan, is indicative of the confidence that the civil society has on the department then to carry on with this responsibility. And I would also like to say to the chairperson that we are reporting to the NSP committees that have the civil society. So civil society is aware of the performance of the NRSO, the numbers that are vetted, and also the removals, because it's information that we provide them on monthly basis. And also the intrinsic interdependencies and data sharing between the stakeholders will remain. It doesn't matter where the register falls, irrespective of where the NRSO or the register is housed. And also, then lastly, the IJS transversal hub is already there. We have that system, and it will make it possible for us to share this data. And we have, as a department, working with IJS so as to make it easy for the NRSO to receive information from SAPS and from all other departments that are feeding into the NRSO. And as I have already presented, that it's only one stakeholder that is excluded there. It is the Office of the Chief Justice, and it is in the process then of being integrated. The engagements with the Office of the Chief Justice has already started. So with that, then, Chairperson,
Can you round up?
Thank you.
Thank you very much. Thank you very much, Advocate Kambule. Thank you for the presentation. Any addition from the SAPS?
Thank you, Chair. To give over to General Lisese from Forensic, who will then give their input on the presentation by Advocate Kambule. Thank you, Chair.
Thank you very much.
Thank you, Chair. I think it should be General Mangale from CRC, Chair. I think General made a mistake. Sorry about that.
General Mangale, over to you. Any comments? Chair, I take it that the SAPS is happy with the presentation and therefore we are content. I submit. Thank you, Chair.
Are you happy or you cannot find the general?
Chairperson, unfortunately, we actually were part of the deliberations with Advocate Kambule. So whatever we saw on the presentation already we conceded to. So we are content. Thank you, Chair.
I'm just pulling your leg, General. Thank you.
Pulled. Thank you, Chair.
Thank you very much. Honorable members, that is the presentations. Any comments or questions or input? Honorable Yako, followed by Honorable Nivo Trachen, then Honorable Horn, Honorable Breitenbach, in that order. Honorable Yako.
Hi, Chair. I'm sorry. I'm basically just trying to juggle a lot of things, but what I wanted to say is this presentation. It really does not look good for the work that we're trying to do in terms of combating gender-based violence and trying to put sexual offenders behind bars and have a public sexual offenders register. For me, the budget is. It seems like it's going to take years for this register to actually be operational. And using all this money, we don't know basically what they're projecting when this will be happening. And it just doesn't seem, it seems like we're also protecting the rights of the sexual offenders. So I want to know from the Justice Department, basically, when does a sexual predator and a sexual offender cease to have or cease to have rights because I believe, honestly, that when you have sexually violated somebody or you have perpetrated gender-based violence on someone, you then lose your right to be treated with dignity. You then lose your rights, basically your human rights, especially once you've been convicted. And I want to know, how are they working with the police department and the justice system and the police department in making sure that the conviction process is quicker? That's what I want to know. Thank you.
Thank you very much. Members, I would like to appeal to members that let's focus on the NSRO because we are still going to go through the bills clause by clause. We asked for this presentation just to look at the feasibility of whether the register should be with the department or with the police. I think let's try and focus on those issues. We're still going to go through the bill clause by clause. Honorable Nivot Drachen.
Okay, thank you, Chairperson. Thank you for the presentation. After looking at the presentation, it seems that the register should stay with the department. Sorry, Chair, Wilma just froze. Okay, so stay with the department, but improve it there in terms of the specifications. So it needs to be improved. Then secondly, I wanted to say in one of the slides in the presentation, I think it was the background, you clearly mentioned that people with physical, intellectual, and mental disabilities, I would rather use generally a general term as persons with disabilities, because if you highlight each individual group, you exclude people who are sensory disabled, like me, for example. So people who are deaf, and then people who are blind are excluded. And our disabled children who are deaf and blind are abused, but people can use that to their advantage because you didn't explain it in the specifications. It's not a physical disability. So please either use the broad umbrella term of people with disabilities, or you need to include all disability groups there. Thank you, Chair.
Thank you very much, Honorable Horn.
Thank you, Chairperson, and good evening to everyone, and thank you for the presentation. Chair, yes, whilst I cannot agree with the Honourable Yaku regarding perpetrators losing rights, it is of course so that and it is relevant to the presentation. I know you said that we will still be coming to a clause by clause. It is of course so that there is, I want to say, a conflicting rights at play when a perpetrator has committed an offense and there's a victim who also has rights, and ultimately the question to my mind is this: should there be a balance of convenience ultimately that rests with victims and society? I get the sense from the presentation that the department strongly feels that the rights of offenders ultimately to be treated in a fair and dignified manner to an extent must weigh heavier than other considerations. In terms of the nature of the register, as well as the accessibility, or the whether it is public in nature, accessible in an easy way, ultimately it would in any event be good to hear from the department what their views are, because I agree with the sentiment of the Honourable Yaku in as far as one gets the impression that the department feels that ultimately the balance of convenience in this instance must rest with offenders. Then, Chair, secondly, I also, like the Honourable Nivo Drachen, get the sense that the department or this task team then was of the view that the purposes of what we want to achieve through the register ultimately will be best achieved through the NSRO in its current or expanded format, resting with the Department of Justice. I, however, must share the apprehension about the ability to deliver through the integrated justice system. Over the years, we've been disappointed on an ongoing and a continuous basis about the lack of real progress regarding the implementation of the integrated justice system. And whilst I am appreciative of the fact that if we are ever going to achieve a functional integrated justice or criminal justice system in terms of IT, and then of course it must be worked, we must work up to a point where also this will in a seamless way integrate with that. But in terms of our immediate needs, will we be able to make this work as a lone standing platform whilst working towards integration? Because ultimately, otherwise, I think all of those decisions regarding the way this must assist our fight against GBVF will be a bit of a I want to say play of words, whilst in reality implementation might be very far off. So if the department could comment on that. And then lastly, Chair, it is always going to be a worry given the fact that we know how the budget of the department and the medium term of the department looks, to be informed that the department is aware that there's huge staffing issues, capacity issues, and that there will be a major need for the adding of both skills and warm bodies to make this work. So it is, I don't know whether it is a question, but it must be stated that it is a bit concerning that it's expected of us to work on the assumption that a proper budgetary allocation is to follow, whilst we know that in all likelihood the Treasury and this department will struggle to achieve that over the next 3 years. Thank you.
Thank you, Honorable Horn. Honorable Breitenbach.
Thank you, Mr. Chairperson. Good evening to everybody. I'm largely covered by the inputs of the previous speakers. I must say I'm a little disappointed. The presentation is great and it all sounds wonderful on paper. I share the skepticism of the Honourable Horn, however, that there will be sufficient budget and resources to make this happen. I still hold the view that the police have a criminal asset register and that system is up and running. It's comprehensive, and I can see no reason why the budget that should or could be allocated to this, some of that budget would suffice in order to expand the criminal asset register to include the National Sex Offenders Register. So I don't know why that isn't a proposition yet. I don't know why that isn't acceptable. And I would like a little more information about that. And then I share the concerns about the integrated justice system. It has never been functional. I'm beginning to doubt whether it ever will be functional. And so on paper, this sounds like a Rolls Royce. I think in practice it's going to turn out to be a bicycle. I'm very concerned about that. I share the concerns about the interests of the sex offenders being placed so far above those of members of society. That's something we'll have to look at, but as you say, we'll do it in the clause by clause. And then I'd like to know, just briefly, if it's possible, what international best practice was looked at in designing this this system, because I've seen some really good ones internationally, and they all are housed within the police system. So I'd like to know what was looked at in this regard. Thank you.
Thank you very much, Honorable Jailer.
Thank you, Chairperson. Can I keep my video off because I wanted to get my background, and it's I don't think it's nice. But I think, Chairperson, you have already covered me. My colleagues covered me in so many areas where I wanted to come in. I think I will agree that let me just wait for the day when we will be discussing it clause by clause, and then from there we'll be able to participate. Because the other concern myself that I was having, it was that issue of making it public and not making it public vis-a-vis the rights of the victim. So, but for now, let me just keep my comments for that day without wasting your time, Chair, and then we'll take it from there. Thank you, Chair.
Thank you very much. Over to your department. DG, can you make comments about budget allocation? Where are you going to find the money?
Thanks, Chair. We acknowledge that budget is a challenge, but however, we are looking at our baseline and see where we can prioritize. I think part of the amount that is projected per annum, the 11 million per annum, includes personnel that we think that we should be able to shift some personnel inside the organization and redeploy them to assist with the NRSO. So what we currently have as projected amount, we should be able to find it. And to the extent possible, I had a proposal for utilization of CARA. Within that framework of CARA funds, we will see if the rules will allow us to utilize some part of it. But broadly, we'll look at what we currently are allocated. I don't think Treasury for anyone, be the SAPS or Justice, will avail any extra money. So we have to look at what we have. Thanks, Chair.
Thank you very much. And then to the interdepartmental team, can you comment on the questions that were asked and the comments that were made?
Is it us? Yeah. Thanks, Chair. I will ask Advocate Skosana to deal with, I think, one or two of those, and Advocate Praise will address the other 2 or 3. I'll start out with Advocate Praise, or Advocate Skosana to address the other 2.
Thanks, good evening. Thanks, good evening, honorable members. And I think I must just add two points to what has been asked. Also to emphasize what DG said, that part of what we are looking at is how we are going to leverage from the modernization program that is currently underway. I must say that we are introducing quite a number of IT systems, which we hope that will give will free some hands. So with those hands can then be channeled towards the NRSO as part of the priority areas, etc. We are working with SAPS. We've also started to yield positive results. And I think we've been engaging ever since we started our workshop. And I think the issue of joint resourcing, where possible, I think will allow us to leverage, because the interdependencies are mainly between us and SAPS more than between Home Affairs and social development. And I think we are looking to areas where during the immediate period we can basically share those resources and see how best can we make this to work, especially where SAPS already have got a local capacity at local level. And I think we can see how we can share those resources and see how they can assist as an interim measure as we move forward. There was a question, some of the people were basically comments which were taken to heart, and I think we'll be able to leverage on that, including the whole issue of broadening our scope to incorporate persons with disabilities, and also to look at a broad category of vulnerable persons than limiting to groups. I think we'll take a note of that. And my colleagues will also come to the issue of the best internet practices. I must just say that there's kind of a mixed bag. There are those where the system lies with police, and there are those which are lies with justice, or there are few. What we thought we were going to do as part of adding on the capacity, already the courts through the registers, whatever, already are managing some of the aspects pertaining to the data collection, etc. And I think the development of systems are going to enable that we also try to use the courts as far as possible to be able to leverage on these capacity challenges. But Alfred Kampula can focus on some of the specific questions which have been asked. Thanks, Chair, and thanks, honorable members.
Thank you, Chair. There is a question that came, I think, from a number of honorable members speaking to the functionality of the NRSO. I would like to say, Chairperson, that the NRSO is fully functional, except, as the presentation says, that it is except with the inclusion of the international sex offenders. We have not yet dealt with that, and we're in a process then, as we're engaging with the Department of Home Affairs, so as to be able then to extrapolate that information from their data system and include it in the register. That's the only area where the register is not operational on. We are vetting, we are removing sex offenders, we are also having the data that actually can be used to do the analysis, the profile analysis of the victims and so on. So it is fully operational, except for that part. I think that is what I would like just to indicate. And also that's to say that then in terms of the IJS integration, as I have presented, that IJS, with our request, has actually moved into speed, into ensuring that all the departments that provide data to the NRSO are integrated in the system. They are all there, as I have enumerated in the presentation, except for the Office of the Chief Justice, and they are in a process of integrating the Office of the Chief Justice, which I think that it is something that might be done with it before the end of this financial year, because the project is started, is already in progress. So with that system then in operation, we will be able to get the data that we need. And DG was talking about the budget. there's a 5 million that is already set aside to ensure that then the integration of all the departments in terms of ensuring that there's information that goes straight to the register is done. So that is what then the IJS has put in their APP, is already in their APP for this financial year, something that they will be doing. So what it means is that by the end of this financial year, we'll be able to get the data that we need for the register, that is from SAPS and also from other stakeholders. Thank you, Chairperson.
Thank you very much.
There's one question.
There was one.
That talks about the international perspective.
Okay. Good evening, Chairperson. In considering the question about which international model was considered, we have considered the UK model in establishing the National Register for Sex Offenders. Because if you can view the UK model and what we currently have, it is actually similar in many respects. Thank you.
Chair, yes, I think we're done from our side.
SAPS, do you want to add anything?
Thank you, Chair. In actually agreeing with our colleagues from Justice, we also want to note that as government in total, we have got serious fiscal constraints, and therefore we are forced to do more with less. I think what we can do is to ensure that in the immediate, we actually make sure that the integrated transversal hub really works and yield results. And then for us to be able to ensure that all our victims actually are taken care of and also are protected in terms of what we are trying to do, but also that all the offenders are marked in the register and therefore are barred from certain activities in society. Thank you, Chairperson.
Thank you very much. Honorable Jala, you said you want to make a follow-up.
Yes, Chair. I think I wanted to, before the meeting, maybe we can adjourn to raise my view on the issue of which side must the register go. I think I'll support Comrade Velma, Chairperson, on that point, and say let it remain with the department for now. Thank you, Chair.
Thank you very much. Any other follow-up question? None. Members, can I suggest, because we are starting tomorrow with both bills to do clause by clause, can I suggest that with respect to the location of register, the drafters have, they must do option 1 and option 2. I think from the discussions, it's clear that there is a view that the register must remain with justice. And there is also a view that espoused by Honorable Breitenbach that it must go to the police. Can the two options be drafted into the bill as option 1 and option 2, so that as we do a clause by clause, we can deliberate and ultimately we have to choose one option, so that we can ensure that the bill is adopted. I think some of the issues that have been raised are part of our ongoing and should be part of our ongoing oversight over the department as to whether once the bill is passed or the bills are passed, how are we going to monitor the implementation of those bills? Those will be part of our ongoing oversight function over the department and the department's consent. Can I suggest that we take note of the issues that were raised by members and those that will need you to tweak the drafting so that you create options, you do that. There was an issue that was raised, but there was no question that was raised by members. It was only raised by Advocate Praise of people under the age of 25. But I think that we will attend to that as we are dealing with clause by clause starting from tomorrow. We have 2 days to deal with clause by clause. We have already dealt with large chunk of the bill over the past months of the 3 bills, especially the 2, because we are done with the first bill. So we have reserved 2 days to go through the remaining 2 bills. We will start early tomorrow morning until evening, because we have to meet the deadline and ensure that by the 4th the 3 bills are passed. So in the light that there is no further comments by members, can we adjourn on that note that we are going to ask the department to have the 2 options, option A and option B, and we will go through the clauses, in fact the bills clause by clause starting from tomorrow. Is that in order, members?
It's in order, Chair.
Thank you. Hello?
Yes, Chair.
Okay.
Chair, Wilma has her hand up.
Okay, Honorable Nevo Drachen.
It seems she's having some technical problems, so I don't know. Okay, so she's back. Chair, I'm very sorry, Chair, to interject. From the discussion, I'm getting the matter of the victims. When we discuss it, can we add the aspect of victim empowerment and equality? Judging from the discussions that we've been having about how it seems the offenders' rights are, it's more in the balance of the offenders' rights rather than the victims' rights. So as we go through it, can we add the factor of victims' empowerment? Thank you, Chair.
Thank you very much. Honorable Jelle, your hand was up.
No, Chair, it's an old one. I was trying to put it down. I don't know how. Thank you, Chair.
Thank you very much. There is another hand here. Is it a member of parliament? Ms. Zintle Cholwane.
No, I'm not a member of parliament, but I am representing Sisonke.
Sorry, Ms. Cholwane. The process we're in now is for members of parliament. We are done with public hearings. We cannot allow you to speak.
Okay, I do understand that, although there is a question that was raised in the chat box. I'm not sure if it can be answered during this meeting or at another time. And this was raised by my colleague, Unosipo.
Sorry, Ms. Sindle. How the process operates is that once the public hearings are done, it's time for deliberation. It's only members that can speak.
All right, Chair. Thank you.
Thank you very much. Members, I don't see any further hands. Can we adjourn and meet tomorrow at, is it 9 or 9:30? Committee Secretary?
It's 9:30, Chair.
9:30. Can we meet at 9:30 tomorrow?
Thank you, Chair.
Fine, thank you.
Thank you very much. The meeting is adjourned.
Thank you, Chair.
Thank you, Chair.
Yeah.